Welcome. I'm Sebastian Mahfood, and you're listening to WCAT Radio, the on-air wing of En Route Books and Media, bringing you the dulcet sounds of Catholic wisdom.
Well, welcome to week 4 of Canon Law 1, General Norms. Let us begin with a prayer, shall we? In the name of the Father, and of the Son, and of the Holy Spirit. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Today we're going to look specifically at ecclesiastical laws. Now, very important in reading the law, understanding the meaning of the law, to recognize what is the matter with which we're dealing. So, this section, Title 1, beginning with Canon 7, is ecclesiastical law. So we're not dealing with divine law. We're not dealing with the natural law. We're dealing with ecclesiastical laws. So these would be disciplinary laws that are quite capable of being mutated, changed, dispensed with, and what have you. Dispensed with, and what have you. All right? So that's just very important. We're not speaking about all law. We're obviously not speaking about the natural law or divine positive law. All right, let's look at Canon 7. A law comes into existence when it is promulgated. Okay, promulgation, I'm going to liken it to this metaphor. The law is born, all right? The law is born, and it is announced, all right? Remember, let's go back to our definition of law. Law is an ordinance of reason, promulgated by the competent authority for the common good. So the law is for the community, all right? So it has to be made known. It has to be announced. People have to know that there's a law. So how does promulgation come about? Well, Canon 8 gives us some insight here. Universal ecclesiastical laws are promulgated by being published in the official commentary, Acta Apostolicae Sedis, unless another form of promulgation is prescribed for individual cases. These laws become effective only after 3 months have elapsed from the date of that issue of the Acta, unless they have binding force immediately from the very nature of the matter they treat, or unless the law itself specifically and expressly suspends its force for a shorter or longer period. So the text is called the Acta, just for short. It's the Acta. If something appears in the Acta, all right, it may not necessarily be law, but it's going to be a rather weighty matter, all right? So in determining, and again, I'm not speaking about law specifically here, but in determining, all right, what's the subject matter here? What's the weight of this document? If it appears in the Acta Apostolicae Sedis, well, that has some weight to it, all right? Laws, universal laws, are promulgated in the commentary of the Acta Apostolicae Sedis. Now, and they are binding after 3 months from the date of the issue of the Acta. Again, there are exceptions. When the Code of Canon Law was promulgated in 1983, it wasn't a 3-month period of time. It was much longer. So the Code was promulgated on January the 25th, 1983. It became effective November 27th, 1983. So it was a longer period of time. Now, again, that time frame between when the law is promulgated and when the law becomes effective, that is what we call a vacatio legis. A vacatio legis. It's a vacation of law. It's that period of time in which the community has the opportunity to familiarize itself with the law and devise ways of observing the law. All right? Let me give you sort of a kind of a homespun example. Let's say that you travel on a specific road every morning and afternoon going to and from your place of employment. And at one intersection there on the road, you see that the highway department is erecting an electric traffic signal. So after the electric traffic signal has been erected and it becomes operational, what happens? Well, it flashes amber for a period of time before it becomes operational, in that it's telling the motorist, all right, this flashing amber light is a warning that in time there's going to be a new obligation here where previously you did not have to stop. Now you may have to stop if the light indicates red. So that flashing amber light, that period of time when the light is flashing amber, that's a vacatio legis. That's a vacation of law. There's no obligation yet, but you're warned a new obligation's coming down the pike, and you better know about it because at one point there's going to be a situation where you may have to stop here, where heretofore you had not. All right, let's look at paragraph 2 of Canon 8. Particular laws are promulgated in a manner determined by the legislator, and they begin to bind 1 month from the date of promulgation, unless another time period is determined in the law itself. So, again, just for the sake of illustration, let's look at particular law with regard to a diocese. Remember, a diocese is a juridic person. That is an aggregate of persons or things. Look at Canon 114. We'll talk about those later. And every juridic person has its own particular law. We call them statutes. So, the diocesan bishop, who is the only legislator in a diocese, may indeed enact diocesan legislation, and he's going to promulgate that in a manner in which he sees fit. So what may be some of these manners? Well, he may promulgate it via the diocesan newspaper if indeed the diocese has a newspaper. So most dioceses in the United States have some type of publication, so it would be indicated there. Certainly, with the advent of modern technology, this could appear on the diocesan website. There may be a situation where the new legislation is to be read at every Mass on Sunday in all parishes throughout the diocese. It could take a number of forms. Again, it depends upon the manner determined, as the law says, by the legislature. Okay, let's look at Canon 9. Laws deal with the future and not the past, unless specific provision is made in the laws concerning the past. So, Canon 9 is dealing with retroactivity. All right, the whole issue of retroactivity. Retroactivity is contra naturam legis. It's against the nature of law. Why? Because there's an inherent feature of injustice. All right. If you look at the Constitution of the United States of America, Article 1, Congress is to enact no ex post facto laws. In other words, retroactive laws relative to prosecution in criminal procedures. So generally speaking, retroactive laws that would look backward, are not binding, and the law is not to be retroactive, generally speaking. Retroactivity does exist with regard to some law. We can certainly, and I'll illustrate that in a moment, certainly in our United States Code, there is retroactive laws. So with regard to, let's say, issues such as taxes, if one earns a specific amount and the tax rates change afterward, before the taxes are due, you're taxed at the higher rate. That's retroactivity with regard to the law, and Uncle Sam is going to get his pound of flesh, as it were. For a practical application with regard to Canon 9, let's look at a marriage case. Let's say that John and Linda are both unbaptized individuals. They entered into marriage, let's say, in the year 2005 before a justice of the peace. John and Linda come to your parish and they are seeking admittance into the RCIA program because they want to take instructions and be baptized in the Catholic Church. Great. So at the Easter Vigil, after they've completed their course of instruction, they are baptized, they are confirmed, they receive the Eucharist, so they receive all the sacraments of initiation. Now, here's the question. Because they become Catholic, does that invalidate their marriage? In other words, they were married in 2005 before a justice of the peace. Well, now, 2013, they receive baptism and become Roman Catholics. Does the reception of baptism and their entrance into the church in some way invalidate their marriage, where it necessitates that a deacon, priest, or bishop needs to witness and they need to exchange matrimonial consent? No! That's retroactivity. The law here, Canon 9. Laws deal with the future, not the past. All right? So, the fact that John and Linda receive baptism and become members of the church, that doesn't invalidate their marriage whatsoever. They're married. They were married in 2005. They exchanged consent before the proper form. The proper form was anything that they found suitable because they weren't obliged to follow the form of Catholics because they weren't Catholics. In fact, they weren't even baptized. So, what do you do with regard to their marriage after you receive them into the church? Absolutely nothing. Absolutely nothing. This is disrespectful, I believe, to the bond of marriage, to in some way feign that, okay, you weren't actually married before you were baptized. Now we're going to go through the ceremony again to sacramentalize, if you will, this bond. That's all nonsense. That is completely inconsistent with the teachings of the church and with the laws of the church. All right? The moment that John and Linda receive baptism, that natural bond of marriage of theirs automatically becomes a sacramental bond. There's absolutely no reason to exchange consent, and it should not be done. That's ridiculous. And whoever does that doesn't know what they're doing. And if they're going to do this under the guise of being pastorally sensitive, I do not believe that they're being pastorally sensitive whatsoever, because they are in some way inferring that John and Linda really weren't married before, or now that the bond has to be, again, in some way sacramentalized, which is insanity. The bond is automatically sacramental upon the reception of both contractors to the marriage. So, you think I feel strongly about this? You're right. Okay, the law deals with the future, not the past, but specific provision may be made into laws concerning the past. So, let's take this out for a spin here, shall we? If you page over to your code and look at Canon 1161. Radical sonation. The radical sonation of an invalid marriage is its convalidation without the renewal of consent, granted by competent authority and including a dispensation from an impediment if there was one, and from the canonical form if it was not observed, and the retroactivity into the past of canonical effects. All right? Now, what in heaven's name does that mean? All right. Let's say you have a situation, we have Bill and Susan. Bill is a baptized Roman Catholic. Susan is unbaptized. All right? Let's say that Bill and Susan are dating. They've been dating for about a year and a half. And let's say that Susan is found to be with child not through the power of the Holy Spirit, if you get my drift. So, Bill and Susan, let's say they're both 20. They come to the Catholic Church. They say, we want to get married in the church. And the priest says, listen, you really haven't known each other that long. There's a child on the way. Why don't you wait until the child is born, things sort of settle down, and then let's look at possibly marriage prep and getting married in the church. Okay, Bill and Susan leave. The parents are very upset. They want Bill and Susan to get married. They want this child to be legitimate. So Bill and Susan go down to City Hall and they attempt marriage. That's the term we use. They attempt marriage and they enter into a civil union. Why? Because it's not marriage. Bill is a Roman Catholic and he is obliged to follow the form of the Catholic Church, meaning that he is to be married in the presence of a bishop, priest, or a deacon. So, Bill and Susan are not married in the church. They're not married as far as the church is concerned. Let's say that after 5 or 6 years, Bill comes back to the Catholic Church and says, listen, I'm a baptized Roman Catholic. I want my child baptized in the church, but I'm not married in the eyes of the church. So, okay. So the priest or deacon says, well, we can convalidate your union with the exchange of consent. So if you, the missus, I want to say the wife, come to church with two witnesses, we will witness the exchange of consent and will validate this union. And Bill says, sorry, my wife is not going to do that. She believes that we're already married. She says she's perfectly fine with our child being baptized Catholic and raised Catholic. She's perfectly fine with Bill's practicing his faith, but she believes she's already married and she's not going to go through some Catholic ceremony. Well, what do? Well, okay, let's look at 1161. You can radically sanate that union. So the radical sanation of an invalid marriage is its convalidation without the renewal of consent, granted by the competent authority, that'd be the diocesan bishop, and including a dispensation from an impediment. Remember, Susan's not baptized, so there has to be a dispensation. We call it a dispensation from disparity of cult. A dispensation from disparity of cult. That is a dispensation that allows a Roman Catholic to enter into marriage with an unbaptized person. All right? So a dispensation from impediment, if there was one, and from canonical form. Canonical form is, again, that you have to be married in the presence of a bishop, priest, or deacon, and two witnesses. All right? That wasn't observed either. And the retroactivity into the past of canonical effects. So what is a radical sanation? Remember, radix in Latin means root, and a sanatio is a cleansing. So what the church is doing is the church is retroactively going back and cleansing that union at the root, so that after the radical sanation, as far as the church is concerned, Bill and Susan were married in 2005. That is one of the rare times when we would have retroactivity in the law. All right? Okay. Let's look at Canon 10 here, shall we? Only those laws which expressly state that an act is null or that a person is incapable of acting are to be considered to be invalidating or incapacitating. All right. Again, remember, I want to emphasize that word expressly. We talked about that earlier. Expressly doesn't mean explicitly. Something can be expressly stated in the law implicitly. So acts are null. All right. And what is null? A null act mean? It means the act has no juridic effect. It has no legal effect. All right. Or that a person is incapable of acting. So incapacity refers to the person, not to the act. All right? So only those laws that expressly say that an act is null or that a person is incapable. All right? So let's look over here with regard to an act that is null. Canon 1057. Marriage is brought about through the consent of the parties, legitimately manifested between persons who are capable, according to the law, of giving consent. No human power can replace this consent. All right. This canon expressly states, though implicitly, that without consent, the act of marriage is null. There's no marriage there. In fact, it's not only null, but it's a non-act. And this is based upon not simply ecclesiastical law, but the natural law. So if there's no consent, the act of marriage is null. So in other words, if it's an arranged marriage and there's absolutely no consent among the parties themselves, it's a null act. There's where the law expressly, though implicitly, states such. Let's look at the term incapable. Now, if you look in the Latin will use the term inhabilitantes. That's the plural. I'm going to use two Latin terms here in the singular. All right, inhabilis, which is the singular form of inhabilitantes, inhabilis, and then incalpax. All right, inhabilis and then incalpax. All right, let's look over here at Canon 1073. A diriment impediment renders a person incapable of contracting marriage validly. And again, if you look over in the Latin text, if you have it, inhabilem, All right, that's a form of the word inhabilis. An impediment is a law that disables a person who is per se capable of the act. All right, let me repeat that. An impediment is a law that disables a person who is per se, that is intrinsically capable of performing an act. Let me illustrate. We have John and Mary. John is a baptized Roman Catholic. Mary is unbaptized. They're both mature adults. They have the psychological and physical integrity to enter into marriage. They are exchanging proper consent, all of those rights and obligations that are essential that the church understands as ordained by Almighty God to constitute marriage. The problem is that Mary is unbaptized, and according to the law, it's Canon 1086, the marriage between two persons, one of whom is a baptized Catholic and the other is not baptized, is invalid. So here, there's an impediment. The law takes a person or persons who are perfectly capable on the natural order of things of entering into marriage, and what do? They disable them. All right? So an impediment is referred to as a lex inhabilitans. It's a disabling law. All right? So an impediment is simply that. It's a law that disables a person who otherwise would be capable. All right? Now, there's a more radical incapacity, and we use the term incapax for that, I-N-C-A-P-A-X. So let's look over here at Canon 1095 under matrimonial consent. They are incapable of contracting marriage. If you have the Latin text in front of you, you see the plural form of incapax, sunt incapaces matrimonii contrahendi. All right? So they are incapable, incapax. This is a radical incapacity. The person is not per se capable of performing an act. In fact, the person is per se, P-E-R, and then S-E, a Latin phrase. It means intrinsically, radically, incapable. So a person who's incapax is radically incapable. There's no capacity in the law disables, as we had in inhabilis. No, this is a radical incapacity. So those who do not have sufficient use of reason, those who suffer from a discretion of judgment, great lack of discretion of judgment, those who are not capable of assuming the essential obligations of marriage, all of these areas constitute a radical incapacity. And so the person isn't inhabilis, the person would be designated incapax. All right? So a person such as this would be incapable of performing an act. Now, Canon 10 also reminds us, again, expressly states, though implicitly, that the presumption of law is that people are capable and that acts are valid and binding. Okay, that's the presumption of the law. This law would expressly state, though implicitly, this presumption of the legislature. Again, read the phrasing. Only those laws which expressly state that an act is null. All right? Let's look at Canon 11. Merely ecclesiastical laws bind those baptized in the Catholic Church or received into it, and who enjoy sufficient use of reason, and unless the law expressly provides otherwise, have completed 7 years of age. All right, 7 years of age, that's the age of discretion, huh? All right? Very important canon here. The ecclesiology of the 1917 Code with regard to Protestants were, all right, they belonged to heretical sects. That's S-E-C-T-S, all right? And they were basically bad Catholics, huh? All right, it's coming out of that Tridentine understanding that these Anglicans and these Lutherans, etc., they were bad Catholics. If they're validly baptized, then they're in the Catholic Church, but they have gone over to these heretical / schismatic sects. All right. Well, the ecclesiology of the Second Vatican Council found there are separated brothers and sisters, and while they are separated from us, there are bonds of unity with regard to baptism. but we certainly aren't going to look upon them as bad Roman Catholics or that they're belonging to these heretical sects. So, Canon 11 is narrating that merely ecclesiastical laws. All right. Now, again, Canon Law in some of these canons that we're going to see, in fact, the canon that we referred to earlier, Canon 1057, that is not simply ecclesiastical law. That's the natural law. All right, with regard to marriage. Consent makes marriage, and consent is among the parties themselves. All right, so that is applicable to every human person. Why? Because it's the natural law as ordained by Almighty God. So it's binding upon every human person. We're not talking about natural law or divine law here. We're talking about merely ecclesiastical disciplinary law. All right? So merely ecclesiastical disciplinary laws bind Catholics and those Catholics who enjoy sufficient use of reason. So generally speaking, the law isn't going to bind a 4-year-old. So the requirement for penance on Fridays, well, the church is saying, oh, Lutherans have to observe that, or Presbyterians. No, that's for Catholics. Let's look at Canon 12 here. All persons for whom universal laws were passed are bound by them everywhere. Okay, we're talking about universal laws. However, all persons who are actually present in a certain territory are exempted from universal laws, which do not have the force of law in that territory. So if you're in a territory that's exempted from a universal law, you don't have to observe that. Let's take this out for a spin for a moment, shall we? Let's look at Canon 1246. Canon 1246 with regard to holy days. Okay, feast days. Sunday is the day on which the Paschal Mystery is celebrated in light of the apostolic tradition, as to be observed as the foremost holy day of obligation in the universal church. Also to be observed are the Nativity of the Lord, Epiphany, the Ascension, most holy body and blood of Christ, Holy Mary, Mother of God, the Immaculate Conception, the Assumption, Saint Joseph, the Apostles, Peter and Paul, and all the saints. Paragraph 2. However, the Conference of Bishops can abolish, boy, that's a strong term, certain holy days of obligation or transfer them to a Sunday with the prior approval of the Apostolic See. All right, June 29th, the Solemnity of the Holy Apostles Peter and Paul. That's a universal law, universal holy day of obligation. Well, that's not observed in the territory of the United States Episcopal Conference. All right, we've been dispensed. All right, or really there's been an indult, not a dispensation, an indult. So let's say, just for example, my cousin Guido, who has a domicile, who lives in Rome, is visiting me here in good old St. Louis, the end of June. All right. Now, if Guido were living in Rome, all right, and he were actually in Rome, well, on June 29th, that's a holy day of obligation. You have to go to Mass. The fact that he's in an area, a territory that is exempted, he doesn't have to go to Mass. Now, let's look at the converse. Let's say that I am over in Rome visiting with my cousin Guido, and it's June 29th. And in my territory, I'm exempted from attending Mass, all right, on June 29th, all right. However, I'm not in my territory. And this is a universal law. And the universal law is observed, let's just say for the sake of argument, in Rome. I think it is, unless the Italian bishops did something they probably did. But anyway, am I obliged to go to Mass? Yes, I am. All right? I'm obliged to go to Mass. All right? Why? Well, look at paragraph 1. All persons for whom universal laws were passed are bound by them everywhere. Paragraph 2 derogates. Remember, we use that term derogation. Part of the law is removed or it's modified. So paragraph 2 derogates from paragraph 1, and it says, well, if you're in a certain territory that's exempted, you don't have to observe that universal law. All right, so paragraph 2 derogates from paragraph 1. Let's look at paragraph 3 here, shall we? With due regard for the prescription of Canon 13, laws established for a particular territory bind those for whom they were passed when these persons have a domicile or quasi-domicile there, and are likewise actually present in the territory. All right, domicile and quasi-domicile is the issue of residency in a territory. So we're going to look at those a little later in the course. But domicile, domus in Latin means house. So a domicile refers to your dwelling where you live. Quasi-domicile, where you live maybe on a temporary basis. Laws for only a particular territory bind only those in the territory. All right? And actually when they're actually present in the territory. Okay? When they're actually present in the territory. Let me give you an example. There was a diocesan law, particular law for the Archdiocese of St. Louis that was promulgated by the Archbishop of St. Louis back in the 70s. And the law was that at sporting events, prelates of the diocese, monsignors, they had to wear a collar. They had to wear a Roman collar. All right? Now, if you're familiar at all with the weather in St. Louis, if you're going to go to a baseball game in St. Louis in June, July, or August, it's hotter than you know what, with the humidity, the heat, etc. And while some of our priests who were monsignors observed the law, a lot of them were overcome because of the heat. So the law didn't last very long. It was abrogated. However, just by way of illustration, that was for those who were incarnated, domiciled here in the Archdiocese of St. Louis. So if a Monsignor went to Wrigley Field or something like that outside the confines of the Archdiocese of St. Louis, the law wasn't obligatory. All right? It was only binding in the territory and for those who had a specific attachment to the territory and when they were actually in the territory. Okay, thank the Lord that law was abrogated. Let's look at Canon 13, shall we? Particular laws are not presumed to be personal but territorial unless it's otherwise evident. So again, this is going back to Germanic law, the idea that law, the jurisdiction of law, the how law attaches is in some way connected with territory. All right, with domicile, with where you live. All right, let's look at paragraph 2. Travelers. Now, what is a traveler? All right, a traveler is a person who is outside his or her domicile or quasi-domicile. That's very important to remember. So a traveler is someone who has a domicile or a quasi-domicile, so they have some type of stable residence. However, they happen to be outside their residence. All right. And the Latin word is peregrini. It's where we get our term pilgrim from that term. All right. Let's look paragraph 2, section 1. So travelers are not bound by the particular laws of their own territory as long as they're absent from it, unless their violations would cause harm in their own territory or unless the laws are personal ones. Well, again, going back to monsignors at sporting events had to wear collars. In fact, I think the law said a coat and collar. Whoa. Well, those are particular laws, all right, and as long as they're absent from their territory, they're not obliged, unless their violation would cause harm in their own territory or unless the laws are personal ones. Well, thanks be to God, that law about wearing a coat and collar at sporting events wouldn't cause harm in their own territory, and the laws weren't exactly personal ones. It was territorial. 2, travelers are not bound by the laws of the territory in which they are present. All right. So, if you're in 1970, if you were a priest, a Monsignor from another diocese, and you were traveling to St. Louis to watch a Cardinal baseball game, again, thanks be to God, you weren't obliged to wear a coat and collar. Nothing against wearing a Roman collar, but golly, in August in St. Louis, wow, it's hot. Let's look at section 2 again. So, travelers are not bound by the laws of the territory in which they are present, with the exception of those laws which provide for public order, all right, which determine the formalities of legal actions, all right, that's a fancy way of saying contracts, or which deal with immovable goods situated in that territory. Immovable goods, we're talking about ecclesiastical goods. We would be speaking about property or buildings. Those would be ecclesiastical goods that are immovable, obviously. All right? Obviously. Okay, let's look at paragraph 3 here. Transients, vagi, are bound by both universal laws and particular laws which are in force in the place where they are actually present. All right. A vagus, that's a singular of vagi, is a person who has neither a domicile nor a quasi-domicile. All right. This is where we get the term vagrant from. All right. Hobo. Okay? They're wanderers, they're drifters, they're nomads. So again, a traveler has a domicile or a quasi-domicile. He or she just happens not to be there. But these Baji, they have neither a domicile nor a quasi-domicile. They're just vagrants. So they are bound by both universal and particular laws in the place where they actually are. All right, so they're kind of hit from both sides. All right, let's look at Canon 14. When there is a doubt of law, laws do not bind, even if they be nullifying and disqualifying. All right, what do we mean by a doubt of law? Doubt is a suspension of judgment. Doubt is a suspension of judgment. Why? Well, it's axiomatic. It's predicated upon the fact that there's lack of facts, there's lack of knowledge. So doubt is a suspension of judgment. So, when there is a doubt of law, laws do not bind even if they be nullifying and disqualifying. So what do we mean by a doubt of law? Well, number one, what's the meaning of the law? Number two, does such a law exist or not? All right? So, if there's a doubt of law, laws do not bind even if they be nullifying and disqualifying ones. Again, remember, we're talking about ecclesiastical laws. We're not talking about the natural law. We're not talking about divine law. We're talking about church laws. If there's a doubt about the meaning of the law, they don't bind. Let's look over here at Canon 9:17. A person who has received the Most Holy Eucharist may receive it, now my translation says again, the more modern translations are going to say for a second time, on the same day, only during the celebration of the Eucharist in which the person participates. All right, if you look over in the Latin text, if you have it, there's a term there, the Latin word iterum. Iterum means again, can also mean a second time. So if you read that canon the way I read it originally and use the word again, that could mean, all right, I'm going to go to Mass 10 times today. And if I go to Mass 10 times, as long as I go to Mass, as long as I stay there for the whole Mass, I can receive the Eucharist. Well, there was a doubt about the meaning of law here. So an authentic interpretation was given, I believe it was 1984, on the meaning of this law. And the meaning of this law, the interpretation was given that the meaning of the law, iterum, means a second time. So you can only receive the Eucharist twice on the same day. All right, not simply as often as you participate in the Eucharist. All right, so if you go to 3 Masses, you can receive the Eucharist twice, but not 3 times. Now, who gave that decision? Well, there's a pontifical council, all right, for the authentic interpretation of legislative texts. All right, what a long title to that, huh? You got to see their letterhead. It takes up half the page. So anyway, that is the organ in Rome, among the Roman Curia, that is charged with interpreting law. One of the organs, all right? Obviously, the Roman Pontiff and the College of Bishops could do that, but that's the specific organ that has been designated by the supreme authority of the Church to do that. All right. When there is a doubt of fact, however, ordinaries can dispense from them. In the latter case, if it is a question of a reserved dispensation, the ordinaries can dispense so long as the dispensation is usually granted by the authority to whom it is reserved. So we don't have to worry too much about reserved dispensations, but let's try this one. This may be a little more practical. Let's say that you are preparing someone for marriage. Someone's preparing for marriage, and one party obviously is Catholic. The other party just doesn't know if he or she was baptized or not. They just don't know. There's not enough facts there, so there's a suspension of judgment. There's a doubt. I don't know. I may have been baptized. My parents didn't really practice any religion, but my grandmother did, and my grandmother, I was with my grandmother when I was a child often, so she may have had me baptized. I just don't know. Well, that's a doubt of fact, all right? And doubt of fact, you can dispense. So in other words, I would grant a dispensation for disparity of cult, as I mentioned earlier, in order for a Roman Catholic to enter into marriage with an unbaptized person. Let's look at Canon 15 here, shall we? Ignorance or error concerning invalidating or incapacitating laws do not hinder their effect in this unless it is expressly determined otherwise. Now, what is ignorance? Okay, ignorance is lack of due knowledge. All right? Ignorance is lack of due knowledge. All right? So according to the definition of law, ignorance is the lack of the knowledge that you, given your state in life, should have. So you are a driver, you have a driver's license issued by a state. The presumption of law is that you know the rules of the road. You know the speed limit. So if you do not, then you are ignorant because you're supposed to know that. So ignorance is want of due knowledge. Error is a false judgment of the intellect. All right, you've made a mistake. You've made an error, either in understanding the law or interpreting or how the law, or even that there is a law. So ignorance or error concerning invalidating or incapacitating laws does not hinder their effectiveness unless it is expressly determined otherwise. Okay, here's what I want you to learn from Canon 15. The law, the force of the law, is not contingent upon the subjective understanding of the individual, because that would render the law meaningless. The law would lose its force. Okay? Each individual, therefore, would become his or her own legislator or judge. All right? So the effectiveness of the law is not contingent upon the subjective understanding of the law by an individual. All right? Let's look at paragraph 2. Ignorance or error about a law, a penalty, a fact concerning oneself, or a notorious fact concerning another is not presumed. All right? So we're not going to presume that there's ignorance or error about the law, about a penalty, about a fact concerning myself, or a notorious fact. That would be a fact that's known. All right? It's well known in the community. We're not going to presume that. Remember, a presumption is a probable conjecture of an uncertain fact. So a presumption is a probable conjecture of an uncertain fact. So here's a legal presumption here. Ignorance or error about a law, penalty, a fact concerning oneself, or a notorious fact concerning another is not presumed. It is presumed about a fact concerning another which is not notorious. All right? So we are going to presume ignorance or error of fact concerning someone else that's not known. Again, I think it speaks for itself. Let's look at Canon 16. Laws are authentically interpreted by the legislator. Again, at the universal level, that's the Roman Pontiff and or the College of Bishops. Again, we make a distinction, never a separation. And by the one to whom the legislator has granted the power to interpret them authentically. Again, that is the Pontifical Council for the authentic interpretation of legislative text. All right, let's look at paragraph 2 here. An authentic interpretation communicated in the form of a law has the same force as law itself and must be promulgated. Furthermore, if such an interpretation merely declares what was certain in the words of the law in themselves, it's retroactive. If it restricts or extends the law, or if it explains a doubtful law, it's not retroactive. So let me just illustrate the canon that I referenced earlier, 917, about the reception of the Eucharist. How many times? Iterum. Well, that's a doubtful law. That was doubtful. All right? There was a legitimate doubt with regard to what was the meaning of the term iterum. Did it mean again, or did it mean a second time? It can mean either in Latin, and so both interpretations, I would argue, could be valid. One could advance valid arguments on both sides. So, the Pontifical Council for the Authentic Interpretation of Legislative Text explained this doubtful law, and therefore, in that case, it's not retroactive. Sometimes the interpretation can declare what was certain from the words of the law, and therefore it's retroactive. In other words, anyone who was reasonable would understand the reasonable meaning of the law, so therefore it would be retroactive. I'm not going to go into examples of that simply because we have time constraints, and we could have a whole course on that. It may come up, hopefully, in marriage law with regard to some issues surrounding marriage law. All right, how about 3 here? However, an interpretation explained in a judicial decision or an administrative act in a particular matter does not have the force of law and binds only the persons and affects only those matters for which it was given. This canon basically reminds us that in canon law, there's no such thing as precedent. There's no such thing as stare decisis. All right? In other words, each case is judged, as it were, in a vacuum, even if we're dealing with the same parties, all right, and generally speaking, the same subject matter. A marriage case, for example, with regard to the nullity of marriage, all right, the case which is being adjudicated, the grounds upon which the case is being adjudicated, all right, the court, the tribunal, isn't going to other decisions of other tribunals and saying, well, this appellate tribunal in the Archdiocese of New York judged this way, and so we have to follow their jurisprudence and their decision. No, it doesn't work that way. Each decision is absolutely in a vacuum because each petition before the tribunal is viewed as being absolutely unique. All right, Canon 17. Ecclesiastical laws are to be understood in accord with the proper meaning of the words considered in their text and context. If the meaning remains doubtful and obscure, recourse is to be taken to parallel passages, if such exists, to the purpose and circumstances of the law and to the mind of the legislator. Let's look at Canon 536. 536 refers to parish councils, The canon reads that after the diocesan bishop has listened to the federal council and he judges it opportune, a pastoral council is to be established in each parish. That's a parish council, all right? Now, the canon doesn't really tell us who should belong to this parish council, does it? That's rather obscure, that it doesn't give us a lot of information relative to, okay, who's on this parish council? What can we do? Well, it's rather obscure. So let's try to go to parallel passages. So here we're talking about a parish pastoral council. Let's see if there's anything in the code about a diocesan pastoral council. Let's look at Canon 511. In each diocese, to the extent that pastoral circumstances recommend, a pastoral council is to be established. Okay? Now, let's look here at Canon 512. 512 gives us all kinds of information relative to who should belong to this diocesan pastoral council. And maybe with the information that we garner from, all right, who should belong to a diocesan pastoral council, we can appropriate that information to some insights as to who should belong to a parish pastoral council. So, Canon 512. The pastoral council consists of Christian faithful who are in full communion with the Catholic Church, clerics, members of institutes of consecrated life, lay persons, all right. Paragraph 2. The Christian faithful who are appointed to the pastoral council are to be selected so that the entire portion of the people of God, which constitutes the diocese, is reflected, with due regard for the diverse regions, social conditions, and professions of the diocese, as well as the role which each of them have in the apostolate, whether as individuals or in conjunction with others. 3. No one except Christians of proven faith, that would be Catholics, good morals, outstanding prudence, are to be appointed to the pastoral council. All right, that gives us a whole list of information as to who should be appointed to the pastoral council for a parish. Let's look here at Canon 18. Laws which establish a penalty, restrict the free exercise of rights, or which contain an exception are subject to a strict or narrow interpretation. What does that mean? A strict or a narrow interpretation is only doing exactly, precisely what the law says, nothing more. Let's look at Canon 1382. 1382, this would be with regard to penalties, with regard to episcopal consecration. A bishop who consecrates someone a bishop, and the person who receives such a consecration from a bishop, without pontifical mandate, incur an automatic late sententiae excommunication reserved to the apostolic see. All right. The bishop who confers consecration and the person who receives consecration, automatic excommunication. Let's say that there are 20 other bishops standing there watching all this. All right. Do they incur the excommunication? No. Why? Because the strict interpretation of penal law is only the one who conferred consecration and the one who received it. Let's look at 515 with regard to the establishment of a parish. Paragraph 2, 515. The diocesan bishop alone is competent to erect, suppress, or alter parishes. He is not to erect, suppress, or notably alter them without hearing the presbyteral council. So, this restricts his exercise of free rights. So, all he has to do is hear the presbyteral council. He doesn't need their consent, but he needs to hear them. And then lastly, so that would be an illustration of a restriction of the free exercise of rights. Again, that's narrowly interpreted. Or contain an exception to the law. All right, let's look at Canon 1421, dealing with judges. The bishop is to appoint diocesan judges in the diocese who are clerics. That's the law. So clerics are to be judges. Paragraph 2. The conference of bishops can permit lay persons to be appointed judges when it is necessary. One of them it can be employed to form a collegiate tribunal. So, this is an exception to the law. All right? Only clerics are to be judges. This is an exception to the law. All right? It derogates from paragraph 1, and therefore it has to be strictly narrowly interpreted. In other words, the diocesan bishop isn't supposed to appoint, just generally speaking, lay persons as judges. No. Lay persons as judges are only by way of necessity. And obviously they have to have the requisite qualifications. Let's look at Canon 19 here, shall we? Unless it is a penal matter, if an express prescription of universal particular law or a custom is lacking in some particular matter, the case is to be decided in light of laws passed in similar circumstances, the general principles of law observed with canonical equity, the jurisprudence and praxis of the Roman Curia, and the common and constant opinion of learned persons. Canon 19 is dealing with what we call lacuna. All right, lacuna. Lacuna is a hole in the law where the law is silent. All right, let me give an example. Let's look back here at Canon 1592. This is with regard to procedural law. If the respondent, that would be the defendant in a case, after having been cited, has neither appeared nor offered a suitable excuse for being absent, nor responded to the court in accord with Canon 1507, the judge is to declare the respondent absent from the trial, and is to decree that the case should proceed to the definitive sentence and its execution, while observing all the formalities which are to be observed. Now, there's a lacuna in the law here because Canon 1592 presumes that the respondent can be cited. Sometimes they're not. Some people are unlocatable. All right? Some people are unlocatable. You might have my cousin Vinny. He's in the Federal Witness Protection Program. Not really. I'm just making a joke. But some people, all right, you can't locate them. So there's a hole in the law. The law doesn't foresee that a person may be unlocatable. Well, what do? Well, you look at Canon 19 and you try to do your best with regard to the administration of justice and equity in the law. All right, let's look at Canon 20 here, shall we? A later law abrogates a former law or derogates from it if it expressly states so. If it is directly contrary to it, or if it entirely reorders the subject matter of the former law. But a universal law in no way derogates from a particular or a special law unless the law itself expressly provides otherwise. All right? So, here we see, we spoke about this a little earlier in Canon 6 with regard to abrogation of the law. We've spoken about derogation of the law. But what is important to remember from Canon 20, a universal law, the universal legislator does not intend to in any way affect particular law, let's say in a diocese. All right? Why? Because law is an ordinance of reason, and the person who enacted the law is a legitimate legislator. And the particular law and the universal law, at least the presumption is that both are going to work harmoniously side by side together. So it would be an aberration, an anomaly, that the universal law would go against the particular law, or that the particular law would in some way be opposed to the universal law. That's Canon 20. Let's look at Canon 21. In case of doubt, the revocation of a pre-existent law is not presumed. There's a doubt of revocation, don't presume it's been revoked. But later laws are to be related to earlier ones, and insofar as it is possible, harmonized with them. So, again, I spoke about this at the outset, this continuity, if you will, with regard to the law. This continuity, if you will, with regard to the law. Because the law is an ordinance of reason, there should be a linear development, a continuity of the law. If law is indeed an ordinance of reason, we're not going to presume that the laws become unreasonable, and so we're going to try to harmonize, try to see the legitimate logical development here. Canon 21 is articulating. Canon 22, which I hate. I hate the translation here. I'm just going to tell you that at the outset. Civil laws to which the law of the church defers, that is a horrible translation, should be observed in canon law with the same effect, insofar as they are not contrary to divine law, and unless it is provided otherwise in canon law. This horrible translation is articulating a very valid principle of law, namely the principle of remittance. If you look in your Latin, at the Latin text of the code, it said, you see, leges civiles ad quas iusse plese remittit. All right, it's the principle of remittance. Now, what is the principle of remittance? The principle of remittance is this. All right, and I'm going to use the vernacular. Legal systems steal from one another, all right? Legal systems steal from one another. Justice Breyer, whom I do not particularly appreciate on the Supreme Court whatsoever, I would disagree with 99% of his jurisprudence. Justice Breyer, one of the justices with whom I'm familiar, who has in his arguments borrowed principles or statements from other legal systems, German law, French law, etc. But legal systems follow the principle of remittance. They steal from one another. So, for example, if you were to look in many jurisdictions in the United States, the civil code with regard to marriage, with regard to impediments of marriage, they have completely stolen those things from canon law. If you look at laws with regard to inheritance, transfer of property, that's all, again, been stolen from canon law. Canon law steals from civil law in that in a diocese, if the bishop is going to erect a new parish and he charges a specific priest, specific pastor with that job, well, canon law is going to canonize the civil law, and therefore the diocesan law is going to say, all right, a church building must be built according to code. I'm not talking about the code of canon law so much as I'm talking about the civil code. So in other words, the electricity, the plumbing, all have to reach the standards of the community for safety and for efficiency. The fire marshal has to give approval for that the building has sufficient exits and is constructed in such a manner that the building is safe for evacuation should there be a problem with fire or some other catastrophic event, that it's a safe structure in which to house people. The building commissioner has to say, yes, the building is structurally sound, and again, people are going to be safe. So the diocesan law canonizes, if you will, the civil code, steals from it, and demands all of these requirements. So, Canon 22 basically is the principle of remittance. Now, Canon 22 also articulates that church law is to be in harmony with civil law, and it basically, again, states expressly but implicitly that civil law is to be in harmony with canon law. If it's not, canon law supersedes. Okay, I think that's enough suffering for today, don't you? Let's conclude in the name of the Father, and of the Son, and of the Holy Spirit. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Thank you very much.
We hope you enjoyed the program, and will join us back for another show on WCAT Radio. This is Sebastian Mahfood. Good day.